You're listening to Cover Your Assets, a podcast that discusses the timely and significant legal issues faced by employers. Kathleen Jennings is an attorney who has over 30 years of experience in advising employers as to their legal responsibilities and has written extensively about employment law in her popular Cover Your Assets blog. If your business has employees, you cannot afford not to have your assets covered.
Hello, everyone, and welcome to Cover Your Assets, the labor and employment law podcast that is gaining popularity. In fact, it's the talk of the town. The question is, what town is that? But I'm here with my resident expert and sister, not necessarily in that order, Kathleen Jennings. Kathleen, how are you today?
Doing great, Tom, as always. Always good to be here with you. And I am looking forward to finding out which town we are the talk of, because that sounds exciting.
It's always exciting to be the talk of the town. And if anyone was listening astutely, they heard a little bit of that computer noise in the background. And that's because I am pulling up the statistics of the podcast and looking at every month we've had a growth of around 20 or 30%, which is excellent. So first and foremost, we want to thank the listeners, the people that are tuning in and obviously enjoying the podcast as much as we are enjoying making it. And then secondarily,
We are.
I think it's been an opportunity for us to learn some things about each other and just spend some time as brother and sister together. And then hopefully people are learning something in the process about labor and employment law, which I know you're going to find this a shock, sis. Sometimes it's not the most exciting topic in the world.
I beg to differ, but what can I say? It's my life.
It is your life. So let's take a look at the numero uno podcast. You want to do last 30 days or of all time?
Let's start with of all time.
The number one podcast episode remains workplace romance.
We must have a very romantic listener base.
This is true. It is kind of weird, though, because we are brother and sister. So, romance. But anyhow, let's go past that one. Legal and illegal interview questions. That is our May 5th episode, is number 2. And restrictive covenants comes in at number 3 of all time. So topics that people are looking for. And today for this particular episode, we are going to tackle a bunch of topics. So this will be even more exciting than usual.
I find them all exciting, but if it's more exciting, I hope our listeners can handle that.
In fact, we're going to call this episode Topic Smorgasbord. I can't spell that word, so hopefully I can look it up on Google to put it in the title. But what do you think? Topic Smorgasbord?
Topic buffet?
Buffet. We'll do buffet.
You could probably spell that easier.
All right. We'll go with buffet for you smorgasborders. But anyhow, that was a term that our mother used to use. Remember? Smorgasbord.
Smorgasbord. She did. Yes.
All right. So our questions today are going to come from a Reddit thread that we posted in the Reddit devoted to human resources. And I don't know who the administrator is if they ever get a chance to listen to this, but I want to thank them because we were able to post one of our show episodes there and then solicit some questions. So maybe we'll have a chance to do that again. Who knows? But this HR human resources Reddit thread is actually pretty interesting. We're able to use it to maybe gauge some topics or gauge interest in topics. And that's what we're doing today. So we're going to pull this from our Reddit thread saying, hey, give us some topics.
I like it. Let's do it.
All right. So
let's hit the buffet, Tom.
Let's hit the buffet. So, right, we got to get our plates. I wish we had a little plate sound effect. If we had one queued up, I'd hit it right now. Number 1, this is coming from a Redditor. It looks like Sithere. Sit here.
Maybe it's a Sith person. Star Wars thing.
Sither, yeah. Sither, sit rep. I don't know. Anyhow. So some of the things that they asked about, and we'll start with this one. And if one of these takes off, we'll just keep talking about it. All right. First one is balancing legal, business, and ethical concerns with equal rights issues. Sounds pretty broad. What's your initial take on that as a topic or a discussion point?
That is very, very broad. I think we would need to focus it better to really be able to talk about it in a way that would benefit our audience.
Well, I guess then maybe maybe I'll see if I can come up with this scenario. So you got legal, business, and ethical concerns with equal rights issues. So let's say you're hiring a secretary, and a secretary is traditionally a female position, correct? So from a business standpoint...
Well, maybe last century. See, when you start stereotyping positions towards certain genders or certain ages, that's when you start getting into problems. So part of dealing with these issues is having your mindset in the right place, which is you don't automatically think of a secretary as a female. And, for some men, an attractive female, that's not a secretary. A secretary is a position that has certain duties, requires certain skills, and you look for a person who will meet those skills and do the job that you need them to do.
Well, and now we've really talked about the balance. There's ethical issues obviously there. So there's stereotyping, as you're talking about, mindset, all those types of things. Because, legally, if you eventually hire, you interview a variety of people for a secretary position, but ultimately settle on I guess considered by society attractive female as a secretary, as opposed to somebody who maybe was less attractive but more qualified. You may not be breaking the law, but there's certainly some ethical issues that are coming into play, is there not?
There would be. And, it depends if the less attractive person or persons are a different gender, or perhaps they're older. Maybe you're looking at potential age discrimination, or are you excluding people from your consideration because they have a visible handicap or disability? Those are also issues that you have to consider. And I think, the converse or a related issue is when you look at jobs that are considered traditionally male, such as construction work, you can't automatically exclude women who apply for those jobs just because, well, we've only had men do this job. No woman can do it. Well, you need to figure out what the skills are that are necessary to perform that job. If that includes physical considerations, they better be a part of the job and not just made up to exclude a certain class of people. And then you have to evaluate each candidate on their own merits.
And again, we're talking ethical issues versus legal issues, but there's a very thin line when it comes to that stuff as well, correct?
Absolutely. You want to do the right thing, or good employers want to do the right thing ultimately at the end of the day. And that's how you stay out of trouble. That's how you cover your assets.
Yeah. And I think that is an excellent point, because ultimately, if you as an employer have a reputation and you have established yourself as an ethical organization, then even when it comes to any kind of legal action, there's going to be more people that will come to your defense, because they will say, no, this is a company that has a strong ethical background. And to that, do you recommend a company adopt a code of ethics and post it prominently, or is that something that could get them into trouble?
It probably depends on the company, especially, and perhaps the size of the company. There's nothing wrong with having a code of ethics. It just depends on what you say in it. And if you have a code of ethics, like any other policy that an employer adopts, you need to make sure that you're going to follow it. There's no sense in adopting a code of ethics if you're going to ignore it in everyday life. It's better off not having a policy than having a policy that you don't follow.
So the takeaway to that is, if you're going to have a code of ethics, you better live by it, Otherwise, you're better off just acting in an ethical fashion, and you don't need a code for that. You just need to act ethically.
Correct. And in this job market, you have to be aware that because there is such competition for good workers, the companies that have a better reputation overall are likely to attract the better workers, the folks that are going to do a good job and stay with you. So it pays dividends also in the employment market to be an ethical company that does the right thing.
Excellent. So let's go to number 2. And this is one I know that you're going to have an opportunity to speak about a lot. And this is how to use your attorney to best effect. And I will say this before I set you off on your answer here. I'm assuming that, when it comes to an attorney, obviously attorneys are not cheap, but they're worth it if you utilize them effectively. I used to have a friend that said that they'd only call the plumber when they had 3 or 4 things that needed to be done, rather than have the plumber come out a bunch and then it cost them a bunch of money. So I think on some level, even though you would benefit from working more for a particular client, I think long run, it's probably better for you to be used effectively so that people will continue to retain your services. So with that being said, again, I know it's broad, but when you retain an attorney or just have someone that you use on a regular basis, what are some of the things that you absolutely should be using them to deal with that are ultimately going to save you money?
First and foremost, you need to be honest with your attorney. You can't hide bad facts or bad information because it's going to come out, and it just makes my job as an attorney harder when I have to deal with them after the fact. The best use of an attorney by a company should be to have the attorney assist in making certain decisions that could result in litigation and get that legal expertise and opinion up front rather than once a lawsuit has been filed. So prevention and that kind of, and getting information about compliance with laws and things like that in advance before you get in trouble, knowing how to comply with OSHA regulations before an OSHA inspector shows up, know your wage and hour requirements. All of those things are information that your attorney can provide to you. And yes, it may cost you a little money up front to get that information, but when you use that information effectively, it should save you money in the long run because you won't be necessarily caught in litigation. Or if you are caught in litigation, even though you're in the right, at least you're going to win.
Yeah. And in this day and age, also, there's a tendency for people when it comes to legal issues, same with medical things, they go to the internet. And you would probably agree with me when I say don't rely on the internet for information when it comes to employment law. There's so many nuances, and there may be a state law and there may be a federal law that pertains to a particular situation. So in the effort to save money, you may depend upon an HR person who says that they're confident that this law is in effect or not in effect or something you don't have to worry about, and then subsequently the internet. But ultimately, it's best practice to contact your attorney and just get that information. And maybe it could be a situation where you have a semi-monthly meeting, put together 3 or 4 questions that you have for your attorney just to verify that you're doing things correctly. And that's the way to be proactive and cover your assets.
Absolutely. And perhaps from time to time, even have your attorney conduct audits of personnel files, I-9 forms, payroll, those kinds of things that can be easily reviewed by an attorney, and the attorney can spot the kinds of errors that will get you in trouble. OSHA 300 logs, things like that. A good HR person will be able to stay on top of developments in the law, or you hope that they will. And there's a lot of good organizations that will help them do that. So The internet can be useful if you're getting the information from the right place. But ultimately, if you have a situation where you're not sure about what to do, or you're concerned that there might be potential liability, that's the time to talk to an attorney and get an opinion.
And what has been your experience in terms of, maybe you have some anecdotal evidence of when you've done an audit and you found something that really could have been a potential problem and you were able to tell the employer to address it immediately and then prevent a problem?
Well, I-9 audits come to mind because those I-9 forms can be complicated. You have to have the right identification and things like that. And it's the kind of thing, if it's not done correctly and you get a government investigator coming and looking at those forms, you're going to get in trouble. Same with payroll. I mean, these are simple things that a qualified attorney can take a look at, not spend a whole heck of a lot of time. Now, if you're auditing things like I-9 forms, you're going to have to go through them one by one, but it's going to save you money in the long run.
Yeah. And those are the types of things that may not seem real glamorous. Everybody thinks of these huge lawsuits that result in a lot of money, or there's some egregious thing going on. And I think in the case of an I-9 or especially paperwork issues, in many cases, this is just clerical error. But unfortunately, courts really don't care about clerical error, do they? They just know whether it's right or wrong.
Or the government. I would say another example would be having your attorney come on site and conduct an inspection of your site in advance of any kind of OSHA inspection. Have your attorney look around and spot potential hazards that will not only save the company the cost of an OSHA violation, which can get up to hundreds of thousands of dollars. It could also save company lives, or at least maybe limbs and things like that. So there's sort of two parts to your OSHA walkthrough inspection by your attorney.
Yeah. And from personal experience, I can tell you, I've worked in the restaurant industry for a long time. There was a restaurant that I worked at that had a foodborne illness outbreak, and their reaction to it was to create a system where the internal inspections, pre-government health inspections, was more stringent than the ones that the government was going to do, so that when the government came through, they would always say, oh, you guys look great. But ultimately, having the company deal with it internally helped to prevent any further foodborne illness outbreaks, identify problems before the government inspectors come in, because I think the best time for you to come through is going to be when the government ain't there, because once they're there, then you're basically going in, and it has to be more expensive for you to walk around with an OSHA inspector than it is for you to walk around before the OSHA inspector gets there if there's not a problem.
Well, potentially it could be. It helps to be proactive rather than reactive. And I can tell you from personal experience with clients, when an OSHA inspector shows up and they see that a company has taken proactive measures to protect the safety of its employees, if it has a good written safety program that's documented, things like that, that also goes a long way toward probably getting fewer violations cited by the inspector, depending on the inspector, because the inspector recognizes that this is not an employer that is careless or doesn't care about its employees. In fact, it does care. And so it benefits the inspector to just move on to somebody else who may have more hazards and care less about the safety of their folks.
And I'm sure that an inspector has a record of previous inspections and that organizations have reputations. And if you already have a negative reputation with the OSHA inspector, you're already starting out in a difficult position. So it would be best to have a good reputation, like you said, having internal controls, and those internal controls that are things that the OSHA inspectors are going to be aware of, because it's their job to know that kind of stuff.
Well, they're going to ask for it. They're going to ask for your OSHA 300 logs. They're going to ask probably for a copy of your safety program. You better have one. You better have your OSHA 300 logs correctly completed and up to date. And, those are the kinds of low-hanging fruit that you can get cited for if you don't do them or don't do them correctly.
All right. And we got time for a couple of more.
That's exciting, Tom.
It is exciting. This has been a buffet of information.
Or a smorgasbord. Smorgasbord.
The red lines in investigations, what you must do and what you must not do. Now, red line, a line that you don't cross. And an investigation, I will have to come up with some maybe, because this is a pretty broad topic, but we'll say an employee investigation. So we'll start at the beginning. One employee, well, here's a scenario. Employees are engaged in maybe an extramarital affair, and that is against policy. Because since workplace romance was such a popular topic with us, we could start there. And then maybe secondarily look at something with financial malfeasance and improper use of funds. But anyhow, one employee goes to HR, reports another employee for suspicious activity. How far can an employer go without getting themselves into trouble, privacy violations, any of those things to ultimately get to what they're seeking, which is the truth, hopefully.
Well, Tom, this sounds like a case for the sex police.
Here come the sex police.
Well, here they come. Now, I do want to say that we do not own the rights to this song, but we do love it.
Love isn't fun no more.
And is that because it's performed by your favorite artist, Todd Rundgren?
It is.
Okay.
So
fantastic.
So we had to have a little bit of levity in here because it's been a smorgasbord. Although I don't think you don't seem to think I'm pronouncing that correctly.
No, it's a smorgasbord with a D.
Board. I see. I thought it was Borg, like a Borg, like a robot or whatever.
It's not a robot type thing.
No. All right. Topic buffet. So back to the red line in investigations. Investigating employee, I'm going to use the word malfeasance because I like that word. What is the red line? Is there a line that you cross? And this actually, I think, goes back nicely to even the first question, which what kind of ethical concerns do you have to keep in mind when you're investigating employee misconduct?
Well, I would hesitate to say that there's an actual red line. I guess I would look at it more in terms of do's and don'ts that the investigator should follow. During this type of investigation, you want to try to safeguard the privacy of the people being investigated as much as you can, but sometimes it's not possible to safeguard it 100%. So you should never promise absolute 100% privacy or confidentiality, because sometimes you may have to reveal a little bit in order to get the information you need to complete your investigation.
Is there a situation where you could be considered violating the privacy of an employee?
That would be a creature of state law. So you would have to look at what the laws in your state say about what is considered an invasion of privacy. Certainly, I would avoid communicating about an employee's private sex life to other employees. That's not necessary. Now, if they're doing things at work, then there may be ways of asking other employees, have they seen any kind of behavior that they considered not work-related or something, but ask in a way that doesn't necessarily make an accusation, but more open-ended.
Yeah. I had a situation where my supervisor came to me and asked me about a coworker who has a condition where they fall asleep on the job, and they specifically asked me if I thought that my coworker was on drugs, which I thought was now you can't see out there. Someday we're gonna have to do a video of this particular show, but not this episode, but you know what I mean, the show. We're gonna do a video someday. But yeah, my sister's look was one of like, huh? But yeah, that's exactly what happened. A guy blows into my room. I'm a teacher and says, "Hey, I'm just wondering, did you, this guy you're working with, do you think he's on drugs or something?" I said, "No, he's got a medical condition that he told me about where he falls asleep at work on occasion." But I just thought it was interesting that that's how it started. So from an ethical standpoint too, I mean, that made me a little nervous as an employee, thinking if this guy's going to be a bull in the china shop when it comes to investigating employees, then yeah. And I don't know what I would have said if I thought the guy was on drugs anyway. Do you think he's on drugs? Well, I know he's on drugs. I was doing drugs with him. I mean,
Is that what you told him?
No, I wouldn't. I wouldn't, even if I was. I wasn't doing drugs with him, just for the record. And I wouldn't do drugs at work with anyone, or just do drugs even by myself. It's not a good idea. That we don't even need to do an episode to tell people not to do drugs at work, unless you are working for a pharmaceutical company and you're getting paid to test drugs. Other than that, don't do drugs at work.
Yeah, I don't know that test subjects are necessarily employees, so I don't even think it'll apply to them.
All right.
But your anecdote does raise another state law issue that you have to be careful about, and that is defamation, which is saying something false that damages the reputation of another person. So that's another reason why you don't want to ask questions in a way that accuses the employee of engaging in the malfeasance, but you want to ask open-ended questions about particular behaviors that people may or may not have seen. Because once you accuse someone, if you ask the question, is Bubba on drugs? And, it sounds like you're accusing Bubba of being on drugs. And if Bubba finds out about that and he gets blackballed in the industry because that gets around, you've got a potential defamation lawsuit on your hands.
And it's important to note, too, that when you're conducting an investigation for anything involving employees, that you ask as open-ended questions as possible. In that case, it was somebody saying to me specifically, do you think this employee is on drugs? Now we're talking defamation, as opposed to saying, I would have phrased it, do you notice anything unusual about Bubba's behavior? And that really can get the same information, but do it in a way that doesn't sound accusatory. Now, I was working with somebody last night when I was bartending, talking about their current employer and how a coworker accused them of doing something. They have the meeting, as I like to call it. And as part of the meeting, the accusations were presented to them from at least from this person's perspective as fact. And I think that can be dangerous when it comes to investigations as well. If you're going to ask questions, don't ask questions that are, and as an attorney, you can't ask a leading question. Is this person on drugs? Is this person stealing money? Have you noticed anything unusual financially?
You can ask, and what's going to happen is it sounds like you've already reached a conclusion, and you may have employees that just go along with it because if my supervisor is asking me this question, they must already know what's going on. I don't know anything, but I'm just going to agree because I want to be a good employee. And so you also potentially taint the results of your investigation by asking those leading questions if you have no basis for asking them.
And you also could violate any employee confidentiality. Especially if you're asking questions related to a specific accusation, maybe an incident that happened when only two people were in the room.
Potentially. I think I would worry more about the injury reputation in those particular situations, because when you start communicating negative information about an employee to other employees, we all know gossip travels pretty fast. And anybody who played that telephone game when they were kids knows also things can get changed and revised down the line. And next thing you know, somebody's accusing Bubba of shooting up heroin in the employee restroom.
Yeah. All right. Well, we've got time for one more. This one should be a quickie. I'm going to ask the question. Now, we may do an entire episode for this. We don't know. We kicked it around as a topic. But for now, we'll just deal with this particular terminology, which is at will. So the question here is, and not every state is an at-will state. This goes back to what we said earlier. Consult with an attorney to determine the status of your state, if it is at will or not. We have 50 of them, so we can't necessarily go through the whole list right now, and we're not going to either way. We may later, because that would be exciting podcast content, wouldn't it?
It would be exciting. I think we may do a whole episode on this at-will employment thing, because it seems to be an issue of particular interest to a lot of people. And without giving too many spoilers, there are some misconceptions about what at-will employment really is.
All right. So let's kind of tease that then. We'll just ask this question, just a quick answer. Does employment at will really mean that I could fire you for wearing red socks?
Yes.
That's crazy, but that's what it means. So if you said, hey, you're fired because I don't like you wearing red socks, then you can do that in an at-will state. So that'll set us up for a future episode on at-will. And we'll close this by saying thank you to the Reddit community again for allowing us to post our stuff. And thank you for coming up with some of these topic suggestions. And hopefully this will be a forum that we'll be able to use a multitude of times.
And thank you, Tom, for actually going there and reviewing these topics so that we have something to talk about.
We'll always have something to talk about.
That's true. You do like to talk.
That is one thing we will never have to worry about. But again, thank you for listening to the Cover Your Assets podcast, the Labor and Employment Law podcast, the number one rated in that is recorded in my recording studio. That is an absolute fact. It's verifiable by me, and of course by you as well.
And well-deserved.
Well-deserved. We put a lot of work into that. And until next time, this is your host, Thom Jennings. And wait, I forget. We've got two things that we always close every episode with: takeaways and your contact information.
Wow. Well, the takeaways, because we've had quite the smorgasbord of topics, is a little harder to come up with one takeaway. I would say probably the biggest takeaway would be get a good lawyer and use that good lawyer to your benefit and be proactive rather than reactive to legal issues.
And that is a recurring theme. And speaking of contact information and having a good lawyer, what is your contact information?
My contact information is email is best way to get me, kjj@wimlaw, WIMLAW.com. Would love to hear from you.
Awesome. And until next time, thank you once again for listening. Don't forget, share, subscribe, pester your friends, make them listen, post us on Reddit, do what you got to do. And we'll talk to you next time on Cover Your Assets.